Hi, welcome. We're glad that you're here and decided to spend an hour of your evening with us. I'm Alyssa DeFilippo, Program Manager for Connections California here at Parents Helping Parents. We are an online statewide resource and information hub for transition to adulthood and adult services. If you want to be at what we need to know, special needs trusts and letters of intent, you are at the right place. This is the second in a four-part series on how to make your loved one's future more secure by utilizing financial planning and public benefits. I will put the registration to the remaining two sessions into the chat, as well as a link to our fall calendar, which is rapidly, far too rapidly, if you ask me, coming to a close. And we will have our spring calendar ready in January, so please watch for that. Again, I'm Melissa DeFilippo, Program Manager for Connections California, and I have the pleasure of introducing Ellen Cookman this evening, our presenter. Ellen started Cookman Law in 2015 to help families of all shapes and sizes plan for the future and utilize available resources. Ellen is a certified specialist in estate planning, trust and probate law from the California State Bar Association, California State Bar of Legal Specialization. And as we all know, many families need parenting when you're gone, and Cookman Law helps families put together a team of professionals with family members to provide additional financial and care management and support. They also offer trust administration services when needed, all very essential things as as some of us enter the aging caregiver phase. So I thank you, Ellen, for being here with us this evening. I thank you, Beatrice, for interpreting, and I will now turn it over. And thank you all for being here, and I'm turning over to Ellen.
Wonderful. Thank you so much, Alyssa. Okay, I'm going to share my screen. This screen. Okay, I'm going to go like this, share, and then I need to press this button here. There we go. Okay, so hopefully
Good.
you all can see that.
It is good.
It's good. Okay, good. Thank you. All right, and I've coordinated the two screens. If you were here last week, there was some non-coordination of the screen, so we're going to work really hard on that this week. So we're talking today about special needs trusts and also a separate letter that you might write, a memo of intent. Alyssa did a great job introducing me. One other thing to know is I do have a son who's 12 who has high functioning autism. And so I was already in this field actually, doing estate planning and special needs planning when he was diagnosed at age 4. And so I went from being, an advocate to a parent. And so I know both sides, and I love the special needs community, and I'm so glad to be sharing this information with you. So last week, you may remember, we talked about the goals of special needs planning. And I think that the most important one is we really want to maximize the quality of life of our disabled loved ones. We want them to be as independent and happy and thriving as possible, while surrounded by some protection and scaffolding to help them to not be taken advantage of by financial predators. We want them to utilize whatever public benefits they might qualify for. We're also setting up surrogate financial parents for them. So we're setting up who will be the surrogate financial you when you're gone. So many parents are up late at night worrying about what's going to happen when I'm gone. We want our kids to be housed, to be in, great situations. And a lot of that depends on the planning that we do now. And also, I am an attorney, but I hate going to court. So we want to avoid the court system whenever we can. Okay, so just a little recap of public benefits. And last week's presentation was all about this slide. So if you have questions about public benefits, go back to that presentation last week. And also I have a YouTube channel where I go over basically every corner of this slide and go into great detail. But the things that we should know for tonight are that there's two main types of public benefits. There's needs-based public benefits, and then there's entitlement-based public benefits. And what's the difference? So needs-based public benefits are basically when your child needs those benefits because they're poor. because they have under $2,000 in resources or their income is low. Okay. In that case, they can receive supplemental security income, SSI, and they can also receive Medi-Cal. So SSI is an income stream and Medi-Cal is a health insurance program. It's the California's version of the federal Medicaid system. SSI has a resource limit of $2,000, all right? And that's still pretty draconian. That's federally based. That means that your child can only have $2,000 of countable assets in order to qualify for that income stream, which is about $1,200 a month maximum. And then if they get even $1 of SSI, they automatically qualify for Medi-Cal. So now compare those to the entitlement-based programs of SSDI and Medicare. So SSDI is if you've worked for a while or somebody else in your family has worked for a while and has earned enough credits to get an income stream when they're disabled, or even when they retire and then they have a disabled child, their disabled child who became disabled before age 22 can get half of what the parent gets, which is child disability benefits. And then after 2 years of getting either of those programs, you can qualify for Medicare. Now, both of those programs are entitlement based, so it means they don't look at your assets. And SSDI, they only look at your earned income, they don't look at your passive income. All right, so really for our discussion today, we're really concerned about the needs-based public benefits. Because what happens if your child receives an inheritance outright? Or what happens if it goes to inherit, and an inheritance goes to your child into a trust that we call HEM standard. It's for their health, education, maintenance, and support. That is a countable asset and it bumps them off of SSI and it can bump them off of Medi-Cal. So what we need to set up is something called a special needs trust for that child. Okay, so what is a special needs trust? Well, first I want to talk about what a trust is. A trust is an agreement between or a contract between the person setting it up and the person managing it. So the person setting it up is typically called the settlor or the grantor. The person managing it is the trustee for the benefit of the beneficiary. And with a special needs trust, the disabled child is the beneficiary. However, the disabled child is not supposed to be the manager, the trustee. And because the disabled child cannot manage the money themselves, they can't control the trust, it doesn't count as their money. It's not a countable asset, so it doesn't interfere with their public benefits. It doesn't count towards that $2,000 limit for SSI. And it doesn't, and any income that's generated within the trust doesn't count as their income for Medi-Cal purposes. So it's kind of like having your cake and eating it too, okay? All right, so what can a special needs trust be used for? There was a case that came out last year, which I think put it so beautifully, all right? It said basically just about anything, okay? Special needs, it encompasses the broad range of everything that a human being needs in order to live, thrive, and realize his or her potential in life, okay? So this is letting you know that it's not just for, a modified wheelchair or medication or things related to the special needs. It's for anything that your child might need to live, thrive, and realize their potential in life. So there's this fallacy out there that special needs trust can only be used for really limited things, and that's just not true anymore, which is awesome. Now, it does depend how the special needs trust is drafted, okay? And some attorneys are not so, this is going to be a theme, right? Some attorneys are not so familiar with how they should be drafted, and they'll draft it pretty limited because they just don't know. And we want to make sure that that's not done for you. Okay, so there's two main types of special needs trusts. There's a third-party special needs trust and a first-party special needs trust. So what's the difference and when would you use each one? So a third-party special needs trust, if you're a parent or a grandparent or an auntie or uncle and you're setting up a special needs trust for a child, and it's your money that's going directly into the special needs trust, you are the third party in relation to the child. So you're setting up a third-party special needs trust because all the money that's going into the trust is going to come from people other than the disabled child. It's going to come from third parties in relation to the child. So we look to see what's the source of the funds for the special needs trust. And that's the type of trust it is. So that would be a third-party special needs trust because other people's money is going into the trust. Now, what if your child um, was functioning and working and then they became disabled? Or perhaps they're disabled and then they received an inheritance directly from a family member. Or maybe they got a litigation settlement and they received some money. And now they have some money in their own bank account, and this is their own money. They can turn around and set up a first party special needs trust and put their own money into that first party special needs trust. Okay, because they are the source of the funds, they are the first party, and they are putting their own money in. Now, there's a few restrictions for a first party special needs trust that don't exist for a third party one. Okay, so with the first party special needs trust, it can only be set up by the beneficiary themselves, the child, if they're over 18 and they have capacity, or by their parent, or a grandparent, or the court. So auntie cannot set up a first party special needs trust for the child. A cousin cannot, okay? Also, the child needs to be under age 65 when they put their money into the trust. Once they exceed age 65, they can't put any more money into the first party special needs trust. And then the biggest limitation for a first party special needs trust is that upon the child's death, Medi-Cal gets to bring a reimbursement claim against any money remaining in the first party special needs trust. They get to, it's basically a clawback. They get to reach in and reimburse themselves for any money that Medi-Cal has paid out during the beneficiary's lifetime. So it's kind of an agreement. They say, well, we'll let the disabled person put their own money into a first party special needs trust and qualify for public benefits during their lifetime, but then we want our money back when the child dies. The third party special needs trust does not have any of those limitations. All right. That one, there's no Medi-Cal payback. The child could be any age. When somebody else puts money in, right? And it can be set up by anybody. So I have a little diagram comparing these. So you can see the third party special needs trust. There's that column where, you know, anybody's money goes in except for the beneficiary's own money, and anybody can establish it. And on the beneficiary's death, the money goes wherever the person setting it up said that they want it to go. Okay. And so you do need to specify in the trust where the money goes upon the beneficiary's death. Okay, so compare that to the first party special needs trust where the disabled person needs to be under age 65 to put the money in. It's limited onto who can establish it, and we do have a Medi-Cal payback. And then if there's any money left after the Medi-Cal payback, then the remaining money goes wherever the trust says. Now, I also put the pooled trust. Okay, so what is a pooled trust? That's basically, we call it a D4C trust because that's the statute. We're not very creative when we come up with names. So it's part of the number of the statute where this is created. So it's a nonprofit organization that basically pools together a lot of smaller special needs trusts. They could be first party or they could be third party, maybe, you know, $100,000, maybe 50,000, or maybe somebody just can't find a trustee to manage their trust. So they said, well, I'm going to join this pool of where they have a case manager and a financial manager, and so that holds the disabled beneficiaries funds, and then the terms of the trust, it's called a master plan, um, uh, reign. You know, that's what you follow, and everybody signs a joinder agreement to join. Okay, so I just want to let you know that's available as well. Okay, so I think the biggest question that we have when you're setting up a special needs trust is, well, we're setting it up for when we're gone, who's going to be the surrogate financial me for Caleb's special needs trust, right? Or for you, for your child's special needs trust, who's going to take over when we're gone? And that's a big choice, okay? So most people, when they're thinking about this, they think of family members and friends. They say, well, they look at the bench of who they know and they say, okay, well, let's see, maybe, auntie might act as successor trustee, but they'll be a little bit old. So I know their sibling will act as successor trustee. And a lot of times I don't recommend that. And I have another slide as to why. But there are some other options. Okay. So there's private professional fiduciaries those are basically individuals who have been licensed by the state of California to manage trusts. This is what they do. Now, not all private fiduciaries act as trustee of special needs trusts, but some do. There's also banks and trust companies that act as trustee of special needs trusts. Okay. There's some nonprofit organizations that act as trustee, and then there's pooled trusts, and then we talked about that. And sometimes you can combine them. All right. So now what about if you name a sibling? Because a lot of times if you have so I have two boys, right? There's Caleb who's 12 and Isaac who's 10. Caleb would not handle it very well if his younger brother was managing his money. That would cause a lot of friction between the two of them. Okay. And also, I want Isaac to be able to move wherever he wants to move and raise his family and not have to be the surrogate financial parent for his brother. The dynamics I don't think would work out. I don't know how, I mean, Isaac's doing pretty well right now, but I don't know how responsible he's going to be in the future. And it's a huge time commitment. If you've ever acted as trustee of your parents' trust, usually that's kind of a wrap up job. Usually it takes like 4 to 6 months. But acting as trustee of a child special needs trust, this is going to last for the child's lifetime. This could last 80 years, right? That is a huge commitment. So a lot of times, family members and even friends do not want to act in that role. And I urge you to not just put somebody down and say, oh, I'm sure they'll be okay. Check with them first. See, how do you feel about this? And we have to do a video called Trustees, Roles and Responsibilities. And I actually made it to scare people because it is such a big role. And a lot of times people don't realize that. Okay, so if you have a family member who wants to be involved in the child in their sibling's life or their cousin's life, but they don't want to act as trustee or it's just too much, they could act as trust protector. Okay, so this is basically somebody who's the overseer of the trustee. They have the power to remove and replace the trustee if things aren't working out well. They can get yearly accountings. They have access to the books. Okay, so they're not dictating, here's how we want you to make distributions. It's a separate role. Okay, but it's really a check-in role, like maybe once a year, to make sure that everything's going smoothly. Because banks can go under. Private fiduciaries can retire or die, right? So a trust protector can also nominate and name a successor trustee. So it does provide that continuity. I think trust protectors are a terrific option, especially for special needs trusts. Now, I do want to mention a structural component that often comes up when we're talking about special needs trusts. Okay. A lot of times, attorneys will set up a revocable trust, and then they push a little button in their forms program that says populate a special needs trust. And so there's a special needs trust embedded within the revocable trust. Now, everybody here needs a revocable trust, most likely, this to avoid probate and to dictate how things go upon their death. And we're not talking about revocable trusts today, but feel free to go on my YouTube channel. You'll find tons of information about it, okay? But just suffice it to say you need one. But where should that special needs trust be located? Should it be embedded within the revocable trust? And my suggestion is no. Instead, I think special needs trust should be 9 times out of 10, they should be standalone, separate documents that are effective immediately. And you might say, well, Ellen, why would we go to all that hassle? I mean, that's a separate document. Why do we want to do that? Well, for 2 reasons, okay? The first reason is if it's set up as a standalone document, it can be funded immediately. If you have another family member who wants to make a gift or a bequest to your child upon their death, they can name the special needs trust that you set up for them. So it's like an empty basket that can receive money from many different sources. Okay. And then the second, if it's embedded within the revocable trust, in comparison, we call it a springing trust. It only springs into being when you're gone. So what if you have a family member who wants to leave money to this special needs trust, but you're still alive? That special needs trust is not available yet. It cannot be funded. So that's one problem. The other thing that I think is even more important is when the special needs trust is funded upon your death, when money goes in, if your child is receiving SSI benefits, for example, you are required to inform Social Security Administration about the trust and send them a copy of the trust. And then they have somebody at the Social Security Administration who doesn't specialize in trusts, but they will review the trust and make sure that it's a functioning special needs trust. And if it's embedded within your revocable trust, they get very confused. You might say, well, see Article 6, that's where, of the revocable trust, that's where it's located. But the trustee succession language might be in Article 3, and the alternate distribution might be in Article 7. And, so they don't know what they're looking at. And you never want to confuse somebody with a government official who's involved in public benefits. If you've ever dealt with the government, when it comes to public benefits, you want to make it as easy as possible, right? So you want to do a standalone special needs trust if you're pretty sure that that trust will be funded at some point. That would be my suggestion. Okay, now what can you put into a special needs trust? Just about anything, really. Okay, you can put, I think the easiest thing to put in there is cash, because then you can utilize it. We set up these special needs trusts to be funded with easily accessible money, money that can be used for the child's benefit. You can put a house into a special needs trust, but you need to make sure that there's enough cash to support the house, to pay all the property taxes, and houses are expensive, right? And any upkeep, anything else, the money is not going to come from anywhere else, unfortunately, right? So it needs to be also in the special needs trust. You can put securities in the special needs trust. It's an account that's titled, anywhere really. Retirement accounts, you can name a special needs trust as the beneficiary of a retirement account. And I have a really good video on this. Oh, I think it's really good. On YouTube, that talks about naming a special needs trust as the beneficiary of a retirement account. You actually get very good income tax benefits for doing that under the Secure Act 2020. All right. You can name a special needs trust as the beneficiary of life insurance. That is a really good way, I think, to fund a special needs trust if you're of more modest means. If you don't have a ton of money, you can get even a term policy that might last for 20 years, but if something happens to you in the next 20 years, then, the life insurance, you can name the special needs trust and the money goes straight into the special needs trust when you die. All right. So it's quite flexible in what it can own. Okay, now one of the big changes in public benefits law was with Medi-Cal. And I talked about this last week, that Medi-Cal, there used to be a $2,000 asset limit for Medi-Cal, but that has been eliminated in California only. All right, so if you move to a different state, their Medicaid still has a $2,000 limit. California is the only one that has joined the 21st century. I feel like we're leading the way. So things have changed. So if you have a child who needs to set up a first party special needs trust, but they're not receiving SSI benefits, so we're not worried about that asset limit, there's a different type of trust that you can set up, and it's called an OBRA 93 trust. Okay, this is basically, it's like a revocable trust that has a bit more structure to it. All right, so somebody else would be acting as trustee, and the trust should not distribute cash directly to the beneficiary, because that cash would count as income for Medi-Cal eligibility purposes. Okay, so there's some nuances here. I'm not going to dive super duper into this, but I do want you to know This is one of the changes. This does not affect how a third-party special needs trust is drafted. This is only if a disabled child would otherwise need a first-party special needs trust, but they're not receiving SSI or veterans benefits, by the way. No, not veterans benefits. I'm sorry, Section 8 housing benefits. One change in public benefits laws is Section 8 or low-income housing has implemented a $100,000 asset limit for eligibility. So if you're dealing with Section 8 housing or SSI, you still need a first-party special needs trust. If you're disabled, you have your own money that you need to put into a trust. Otherwise, for Medi-Cal, SSDI, Medicare, you can get an OBRA 93 trust. Okay. There's also, we should think about what about our neurotypical children? What might they need? Okay. So for those children, I like recommending a dynasty trust or a lifetime trust. These are also called GST trusts. Basically what happens is they receive their inheritance into an irrevocable trust, kind of like a special needs trust, but different. Because the child themselves, if they're mature enough, they can take over and manage their own trust. Now, why would you want to do this? Well, it provides great protection from divorce. All the money that goes in is segregated. It's their own separate property. So you don't have to worry about if they get divorced, the ex-spouse takes half. That doesn't happen. Also, there's a high level of creditor protection if your child is sued. It's an asset protection trust. In California, we can't set up our own asset protection trusts, but you can set up one for somebody else. And that's basically what this is. You're setting up an asset protection trust for your child. I don't want us to forget about planning for the neurotypical siblings. So I did want to put that in. Now, what I'd like to do is pause for a minute because I want to talk about the memo of intent. But Alyssa, I was thinking maybe we could pause and see what questions are out there about the special needs trust or the different types that we have, and maybe answer some of those before we go on. Would that be possible?
Sure. Let's just take a look at the questions. Taking them as they came, if a special needs adult or child, I think, inherits money, can that be set up as a third and not a first party trust?
Well, the problem is if it's their own money, it has to go into a first party special needs trust. They are the source of the funds. Now, one thing that people might try to do is have them transfer their money to a sibling or to somebody else who would then put the money into a third party special needs trust, but that's very dangerous because if Social Security Administration finds out about this, they'll conclude basically that you're doing this to get around the first party requirements. So typically you do need a first party special needs trust.
Okay. And how about compensation for trust protectors? Do you have anything that's appropriate for compensation for trust
Gotcha.
protectors?
Yeah, they can be compensated. Typically it would be hourly. How much would you pay them? I don't know, maybe $50 to $100 an hour. But it should just be like a once a year thing. So it shouldn't be a huge cost, and it shouldn't be a huge time expenditure.
And how about the relationship between special needs trusts and Section 8 housing? Does one exist?
Yeah, so special needs trusts are very important to protect Section 8 housing. I I have a video on that, by the way. I didn't make a slide about it. I know I have a video on just about
I
everything.
have a video on everything.
I know, I feel like Elizabeth Warren when she was
Yeah.
running, right? She said, I have a bill
I
for
have a
that.
video for that, yeah.
Yeah. So there are some special rules about, putting money into a special needs trust, and then does that count as their income? No, typically not. Okay. If you have money in a special needs trust, and this applies for all public benefits, if you have money in the special needs trust, what you do is you use the money to buy stuff and to pay vendors directly. And as long as you're not distributing cash to the child, and then the child buys things, or you're reimbursing the child, you don't want any cash to go directly to the child. Because if it does, that counts as income. And that can interfere with Section 8 housing.
So no income to a child or adult who
That's
is
right. Now, if the child is trustworthy and, they can have a credit card or a debit card that the special needs trust pays off the invoice every month. So you can build in some flexibility. There's also something called a TrueLink card, which is basically a debit card that can be programmable. So you can say, all right, this can be used to pay for, food but not cigarettes, right? So you can pick and choose that way.
And should the SSA, the Social Security Administration, get a copy of the standalone special needs trust at the time it's drafted or at the time that it's funded?
So that's a really good question. It should be at the time it's funded. However, what they're doing more and more, and maybe this question, the person writing this question might be aware of this. When you apply for public benefits for SSI for a child, they will ask, does the child have a special needs trust set up? And you're required to say, well, yes, but there's no money in it, right? But they might still ask to see a copy of the trust. They never used to do this, but in the last few years, they've been doing this more and more. And I'm not mad at that. I actually think that can be good because then they're looking over the trust and you can find out if there's any problems with them, if they have any objections to it. We call this type of trust a seed trust, SEED, which means you put in $10 or $100. It's just to set the structure of the trust, but you don't need to get a separate tax ID number. You don't have to file separate tax returns. It's not up and running. But yes, nowadays, for some weird reason, the Social Security Administration has been asking to see copies of trusts when you apply for public benefits, even if it's not funded yet, and you are required to send it to them. But if it's drafted properly, it's fine.
That's why it's important to have it drafted properly.
Exactly. That's right.
Yes.
That's right.
Okay, so we're going to limit questions to special needs trusts right now, and if we have time at the end, I can ask some more general questions. But let's just keep with the special needs trust now.
Okay.
When a third party special needs trust is funded, who's responsible to inform Social Security Administration? The trustee of the special needs trust or the representative payee?
The trustee. The trustee is responsible. Yeah. The rep payee. So if most of you are probably familiar with that, but that's the person who's responsible for managing the SSI income or SSDI payment every month. That's their sole responsibility to manage that stuff. For anything related to the trust, notifying about the trust, filing tax returns, that's all the trustee's responsibility. And that's why it's so important to name the right trustee. You can have a perfectly beautifully drafted trust and name the wrong trustee. In fact, can I give a horror story? Would you mind, Alyssa?
Not at all.
Let me tell everybody a horror story. All right. So there was a special needs trust that was drafted for a disabled individual who was living in a group home in LA. And he had a brother in Florida who was managing the trust, and then he had a sister in the Santa Cruz area. And the brother in Florida was taking out promissory notes against the special needs trust to pay for his kids' college education. And he had no way of paying that money back. He didn't have much of an income, but he figured his brother, who's in this group home, doesn't need the money. Well, guess who the president just became? I don't know what's going to happen to the public benefits program. We might need special needs trusts a whole lot more in the future, right? So basically, the sister had to sue the brother in Florida to remove him as trustee and get him to pay back all that money. All right. So the special needs trust was drafted fine. They named for sure the wrong person as trustee of that trust. So you really have to be very careful. The name trustee, it comes from that term trust, right? It's somebody that you trust to do the right thing. And that's why, it doesn't go through the court system, which is nice, but the drawback is you don't have a judge overseeing it. So that's why building in some sort of oversight, especially if you're naming a professional, can be a really good thing.
Another reason not to name a sibling, potentially.
There you go. Exhibit A, right? Yeah. Yeah.
Can you have a first party and a third party special need trust if needed based on the type of income the beneficiary has?
You bet. You bet. So sometimes, clients will come in and their kid already has $150,000. Maybe they had an UTMA account that, cashed out. So it's their own money that they need to put into a first party special needs trust. And then the parents want to leave the kid money when they die. And so we set up a third party special needs trust. So in that situation, we would draft both of them, but we would only fund the first party special needs trust now. So we could protect that money. And so that person could then apply for SSI benefits. And then at the parent's death, that's when the parent's money would go into the third party special needs trust. And basically you have two tax ID numbers set up, you're filing two tax returns. It's a little bit more hassle, but you're protecting this child's benefits, which is super important. And you're also providing that scaffolding, that protection from financial predators that I was talking about.
And in talking about filing tax returns, there is a question about finding CPAs who know the tax filing requirements for SNTs.
If you know somebody, please let me know. I have struggled to find, and well, first of all, it's almost impossible to find a CPA in the area, in the Bay Area, regardless. Okay.
Mhm.
But it's even harder to find specialists who, and I don't know of any. However, what you really want to find is somebody who's familiar with filing a fiduciary income tax return, a 1041. And that is the same type of return as, say, for a dynasty trust or some other irrevocable trust. It might be a marital trust, a
Mm.
bypass trust. So a special needs trust has a few other tax features, but otherwise it's similar to filing another irrevocable trust.
Okay, and you just mentioned dynasty trust. There is a question about a dynasty trust. If the beneficiary is receiving both a Medicare and Medi-Cal, then is the special needs trust the way to go instead of a dynasty trust?
Well, you might want to do an OBRA 93 trust.
Mm.
So you'll want to, meet with an attorney to talk that through. We thought, oh, great, they've eliminated the asset, limit for Medi-Cal. Now things are going to be so much simpler. We always think that it becomes more complicated, honestly. There's more options, more choices, which is great, but figuring out which choice is best for you and your family, usually that does require some professional assistance.
Okay, so as happens a lot when we take questions during the presentation, they just keep rolling in. So I wonder how much more you have to go of your presentation so that
Yeah,
we
I
get
don't
through
have
the
so much
presentation.
more, but why don't we move along?
Yeah,
We'll
I
we'll
think
do
that might
those,
be a good idea.
and then we
Return to
can
the
sort of, I
presentation.
figure there's going to be a lot of questions. So
Yes, yes, and they
okay.
just keep coming unless
Oh,
we
okay, okay, good.
unless we stop them. Right. Okay.
I
Thank
love
you.
it. Okay, so let's do that, Alyssa. Great call. All right, so let's talk about the memo of intent. So what is this? Um, it's a separate document from the special needs trust. It's not included in the special needs trust. And this is basically a Dear Successor Trustee letter, especially if you're naming a professional or someone who doesn't know your child that well, or even if somebody who does know your child pretty well, but not as well as you know them. You've lived with your child for their entire lifetime. You know what makes them happy, what makes them sad, what traditions your family has built up. You might want to make things as standard and typical as during your lifetime to keep those traditions, those flows going the same. Um, and and ultimately, the stress of losing a parent is so challenging, even for neurotypical individuals, right? It's it's 10 times harder for a child with special needs. And so we want to make that transition as smooth as possible. One thing that I'm not talking about tonight, but I want to point out is housing. All right. A lot of people, perhaps even on this call, have their children living with them. Okay. I think that it's really important to at least start looking around, looking into housing options for your child for when you're gone, and perhaps to even transition them into the group housing or into the condo or wherever you might have them, living in the future. And then you can go and visit them every day or check in with them, but they can start developing their relationships outside of your home. So when you're gone, they already have the support structure in place. But that's just an added bonus. Okay. So what do we find in the memo of intent? Well, you can talk about basically anything. Okay. If you know how you want your child to be educated, if there's certain trade schools that you think would be great for them, write that out. If there's things you've already looked into, please describe that. I've had some clients who have had really amazing caregivers, and their kids are very close to their caregiver's family. I live in East Palo Alto. There's a huge Tongan community here. I had a client whose caregiver was Tongan and would bring the disabled child along to the Tongan get-togethers, and that was really, really important and wonderful and healthy. And so they wanted that to continue. Now, if you named a bank or somebody, they wouldn't know this Tongan family from anyone. But if you put it in the memo of intent, they know, okay, this is an important component. They can oversee visitations, but just make sure that you're keeping those connections that your child and you have worked so hard to cultivate. If they have hobbies, if they like going to the Special Olympics every year, or they're really into trains and they love going on such and such train every year during Christmas time, right? These are the things that you can write out. Also, medications, super important to document those. You might even just want to have a separate document with that, especially for our medically fragile children. But definitely let people know about that. Now, do keep in mind that if you name a professional, sometimes they'll actually hire a care manager to help administer kind of the more personal components, like going and visiting them and helping them with their meds and stuff. That may not be something that the trust officer does themselves. Okay. They might hire that out, which I think is good because you want the people who specialize in each thing to do that. If they have allergies, very important to detail that. Okay, now, so when we're working with a client, we typically put together a guide, and this is kind of, you'll see this. I don't want to go over this, but goes over like what should be in this letter. It's something that you update every few years. That's what I recommend because your child grows and has different likes and dislikes. They develop, even if a child has developmental delays, they're still developing. It just might be, a little bit more delayed than their neurotypical peers, right? So you can write it in whatever language you want, very accessible, all right? And then here are some things uh, to spell out, especially you notice I did put in living arrangements. That's huge. And especially in the Bay Area, it's so expensive. If you go to any coffee shop, many of the conversations are about, how expensive housing is here. So you want to set them up for success and figure out what that could look like. That's something that's really important, I think, to speak with a professional about. You can do financial projections to see how much money needs to go into that special needs trust to last for the child's lifetime. Those financial projections are usually done by a financial advisor. So you can pull them in, pull in your CPA, and we call that like the professional trifecta: the attorney, the financial advisor, and the CPA. Those are really the three professionals that are so important as you're doing this type of planning. Okay, so that's kind of a very brief overview of the memo of intent. I wanted to also just say here are kind of some suggested next steps. I like putting this in because sometimes when you receive a lot of information, it can be like a deer in the headlights. What do I do next? I recommend that you look over your own estate plan, especially the special needs trust, and see how does it match up to what we were just talking about. And if you think it needs to be updated, especially if it hasn't been funded yet. If the special needs trust has money in it, it's typically it's irrevocable. It's harder to change. Okay, you might have to go to court to change it. But if it's an empty basket, or if it's part of your revocable trust, you can definitely modify it, or you should be able to. So that's something to go to an attorney about. Laws change, even that question about, hey, we have Medi-Cal, but not SSI, what type of trust? I have different advice today than I had it a year ago. right? So laws change, so it is important to go in to your estate planning attorney, and please go to somebody, even if it's not me, go to somebody who understands special needs planning, because it is so public benefit specific, and also just specific as to, you know, your child's housing and their future, and what do you do. And also, I do encourage you to share the information that you've learned. You know, you'll get this slideshow, and you can also get the video and forward it to other family members and friends that you think could benefit. This is a sketch of our firm. We are all-woman firm located in Palo Alto, but we serve people all over California. Um, Estate planning is state specific. So if you live in a different state, or if your disabled child is in a different state, we can make a recommendation for somebody in that state, but we wouldn't be able to do the planning for you because it's really focused on California. We do estate planning, special needs planning, and trust administration. We don't assist with public benefits applications, okay? And then you have heard me talk about my YouTube channel, so please go on and subscribe and like, and look. I think we have 130 videos on there now, so you'll find most likely, you know, whatever topic you're looking for, just enter it in, you know, Ellen Cookman Law, and then the topic that you're looking for, and it might show up. And we're also on social media on Facebook and LinkedIn. And I also, this is the page that I wanted to keep up while I'm answering questions, because you can scan this QR code to be added to our mailing list. We send out, I think, very informative newsletters once a month to your email. And if somebody comes in and mentions that they attended this, we will make a $300 donation to Parents Helping Parents, because I'm a huge fan of PHP. They do such an incredible job in our community. So that's our presentation. So let me bring it back to Alyssa and see what other questions, and then I can also bring up the Q&A box. But Alyssa, I love how you've been kind of facilitating that.
Sure, happy to do so. But first, I'm going to draw everyone's attention to the chat, where there are a couple of questions. I hope that I'm able to get back to them, but we'll take the Q&A questions in the Q&A box first. But there are those evaluations I talked about. There's a link in Spanish and there's a link in English. Please click on it for very simple questions. You can answer them as you're listening. You know, one finger is pressing agree, very much agree, very much agree, because you all love the presentation, right? So that's what you're going to say. But the other can be listening to the answers. So please do that. I'm going to be checking to make sure that we get at least 75% this evening filled out. And like I said, I promise I can be annoying about it. So back to questions. Child support payments, can they be deposited into an account that's tied to a third-party trust?
Child support. All right. So adult child support is tricky. And I have a video where I go into this, but I'm going to kind of give a summary. All right. So basically, you need to work with your family law attorney and an estate and a special needs planning attorney, and create a first party special needs trust. And then you irrevocably assign the child support payments to the first party special needs trust. So it can't go into a third party special needs trust, because really it's considered the child's own money. But if you do that irrevocable assignment, then you are protecting the child's public benefits. But that's really the only way that I know of to do so.
Okay. And is there one best resource that you know? I mean, I could put in the chat our financial planning Connections California page, which has some resources about what's allowed and not allowed regarding expenditures for a special needs trust. But do you have an all-time favorite that you'd like to share, and I could drop it in the chat?
Oh, you bet. So like, what can a special needs trust be used for, and just all things administering
Yes.
special needs trust? Yes.
Yes.
Let me turn around and get it. I have a book.
Okay.
All right.
Oh, a book. What's a book?
What's a book? Exactly, a book. Okay. So I'm advertising another attorney's stuff because it's so good. So this is called Administering the California Special Needs Trust. It's by Kevin Urbach and Michelle Fuller Urbach. All right, and they're on the East Bay. And I love it because for the table of contents, it's questions, right? What are a special needs trust trustee's duties? And then it sends you to page 9. So it's very user friendly. Okay. And I think you can order it on, Barnes and Noble or Amazon or wherever you get your books.
So administering a special needs trust,
Administering the California Special Needs Trust. And I think
administering
there's four editions. Oh no, this is the third edition.
California.
So you'll
And
probably want the most recent edition.
Kevin is his first name, right?
Kevin Urbach, Urbtsch.
Yes, yes. Okay. He's on my list of people to maybe come and speak to
There you
PhD,
go. There you go.
actually. There you
He's
go.
kind of the godfather of special needs planning. And
Ah,
if you have like a litigation settlement and there's what do you call it? A structured settlement, he does a lot of that type of work.
okay. Well, I just put that book into the chat as well. I will also include it in the email that goes out to everyone, so you will have that. Again, I'm just going to draw your attention to those links, the English evaluation and the Spanish evaluation. Please just click on them for short questions. Yeah, we're getting there, but we're only about a third of the way there. Okay, we did the child support. We did the resources. Something about taxes are high in IRAs in a special needs trust, and you were saying the
Oh,
taxes
yes.
are low?
Okay, so
The confusion.
so really, I think the question that this person might be addressing is how are retirement accounts taxed? And so here's the problem. If you have income that's generated in a special needs trust, how is it taxed? Okay. So let's say, there's $1 million in there. That's the principal. That's not taxed. But let's say it generates $30,000 of income, okay, or 50,000. Okay. If you use that money to benefit the child, to buy stuff for the child, all right, that income, then you would report the income on the K-1 form that's attached to the child's own income tax return. And the child reports that income to the IRS at their very low marginal tax rate. Okay. That does not count as income though for public benefits purposes. That's where the confusion often comes up. If I'm reporting this as income, oh no, now it's going to interfere with SSI. No, as long as the money is not distributed as cash to the child, but as stuff, buying things directly from the vendor, that does not count. That's income for income tax purposes, but it's not income for public benefits purposes. They define it differently. All right. Now let's say, you've generated $50,000 of income that year, but you've only used 30,000 of it for the child's benefit and 20,000 has been retained in the special needs trust. That $20,000 will be reported as trust income. And the trust tax brackets are compressed. So you get to the highest tax bracket of, what is it, 38.6%, something like that, at a much lower amount, at $13,000 basically. Okay, $13,000 of income. Whereas for an individual, you'd get there at what, $400,000, $500,000 of income, right? Basically, trusts do not have very good lobbyists. So this has not been updated. So the goal is to distribute all of that accrued income out to the beneficiary's benefit. And as long as you do that, then then the income is reported on the child's lowest marginal tax rate. Now, how does that relate with retirement accounts? It's the same thing. Okay, so there will be, you do have to pay the required minimum distributions each year, but as long as that money is utilized for the child's benefit, it's reported at the child's tax rate, not at the trust tax rate.
Okay. Phew, that was.
Yeah. And I have a video about taxation. I think that's what it's called, taxation of special needs trusts. And I go into detail on that because it is very confusing. And sometimes you have to hear it 3 or 4 times. I feel like it's like a new language, right? It's like, I learned Japanese a long time ago. I lived in Japan for 3 years. It was a lot of fun.
Wow.
And, but I remember when I was learning a new word in Japanese, I'd have to hear it like 7 times and put it in a sentence and see it on a billboard. And then finally I retained it. Estate planning is the same way. We have weird terms and different concepts. You think, oh, I'm an engineer. I'm really smart. I should be able to understand this. Not necessarily. I don't understand the language of patents. People don't necessarily understand the language of special needs planning. That's okay. The more times you absorb it, the more times you learn it, the better you're at.
Hmm. Yeah. Hope for the future.
There you go.
Um, uh, okay. Is the irrevocable assignment to the first party special needs trust for the adult child support considered support from the parent or from the child when considering the support test for dependency claiming?
I'm not sure. I think I
That was quite the question.
yeah, no, that's a little bit too specific for this presentation. Yeah.
Yeah, okay. And that might need a little bit of a consultation.
Okay, yeah.
Okay, now looking at the clock on the screen, it's 7:28. We're not going to finish all these questions in 2 minutes. Do you want to just take a few more and go to 7:35? Yeah.
Yeah, I'm okay staying on. If you need to leave, I'm not hurt, but yeah, we can take a few more.
Okay, how about a softball? If the special needs trust has more than $100,000, does that affect public benefits?
Nope. It can
You
have
like that one?
5 million, 10 million, anything. You might be thinking about able accounts. That's a different presentation. Definitely make sure to go to that presentation and
That's
you'll
coming
learn
up.
about limitations for that.
That's right. I did put the link to that in the chat. And again, I'm going to direct your attention to those two links to the evaluations just to click on it and answer those four very simple questions. We're almost to 50%, which is, 25% away from my 75% goal. So, I'm going to keep going. Um, if my child is very independent and self-sufficient, does he need a special needs trust?
Well, it really depends. It depends on the situation. It depends on the benefits that your child is receiving. If you think so there's a difference in my mind between your child being able to manage their day-to-day money, right? Like if they don't have a rep payee and they're getting the 1,200 and they're living off of that and they're doing a very good job with their budget, that's awesome. But if they're receiving an inheritance and they're going to be managing $1 million, $2 million, are they up for that? That's a different skill set, I think, than being able to manage a budget. And I mean, even like if you had told me, hey, Ellen, you're going to be inheriting $2 million, but somebody else is managing it, I'd be like, great, sign me up. So I think, being able to protect a child for their lifetime is very important. You can always build in flexibility to say, hey, if this child is not receiving these needs-based public benefits, then they can get $30,000, $50,000 of cash each year. That's okay. But I think for large chunks of money, I usually recommend bringing in somebody who's a bit more savvy with management, investment, income tax, all of that.
Wow. Okay. We're getting some specific questions here, this is really not the forum for that. But another, I think, simple one, I think I even know the answer to it. Should the child be named personally or the special needs trust as the beneficiary of a life insurance policy?
What do you think, Alyssa?
I think it should be the special needs trust.
Yes,
Yay! Ding, 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 ding.
that's right.
Yes.
That's right.
Okay. Um, what if the extent of the child's disability is not known yet? And you're setting up an irrevocable trust, special needs trust, but then the child grows up to be more independent than anticipated. Kind of like the same question that was asked before about
I
the
love that
independence.
question, actually. It's a little bit different. And what I like doing is building it because that happens a lot. Like even my 12-year-old, he's super smart, he's doing great, but I don't know. I don't know how he's going to develop, right? So I like putting in some flexibility into my special needs trust. Sometimes we add a toggle switch. We say, if the child, upon my death and the trust is about to be funded, if the child is receiving needs-based public benefits, or if it looks like they need them in the future, then
Hmm.
it toggles over to the special needs trust.
Hmm.
If it looks like they're not going to need public benefits in the future, it can toggle over to a dynasty trust that the child can manage themselves. You can also put in the special needs trust. You can say, if the child is able to work and support themselves for say 3 or 5 years and, get health insurance from their employer, then this trust can morph into a dynasty trust. So there's several places where you can build in that flexibility.
Lots of thank yous, lots of thumbs up, lots of hearts. I thank everyone for coming, and we'll see you again next time.